All right. Please sit down. Please sit down. There will be a coffee break after the next session, and you can continue your conversations. So I want to begin with an organizational announcement. As you know, if you look at the program, we have two kinds of panels. We have the plenary panels, the plenary sessions, and then we have the ordinary panel sessions. Now, all of the plenary sessions, all of them, today, so this one, but also tomorrow and on Sunday, will be taking place here. It's in the program, but just for your orientation, they will all be taking place here in the Auditorium Maximum of the main building of Humboldt University. After this session, and for the panel sessions, the ordinary panel sessions, so not the plenary ones, but the ordinary ones, they are distributed among 3 buildings. Now, all the information you need, you'll find in the program, in the map on page 6. But just for your orientation, there are 3 buildings, they're all within easy reach, and you can all get there from here within 3 minutes. So if after this panel you want to orientate yourself, either ask someone in a red shirt or take a good look at the program and the map and you'll be oriented. Okay, thank you. We go to the panel.
Thank you very much. First of all, I would like to say how pleased I am to attend this conference, and I thank the organizer for having invited me to chair this plenary. Not that I am a great specialist of migration and movement, but I will specialize in giving the floor to others who are far more gifted than me to speak about this topic. So our panel will try to show how much the problems we are currently facing are not new. And I don't mean nothing has improved, of course, but nevertheless, the problems are not less acute. Both our speakers will invite to contextualize the issue and to take a historical perspective, although they will do it in a very different way, one to the other. So the first panel, in fact, will be Philip Sands, who is professor at UCL and author of a recently issued book, East-West Street, you can see it, and on the origins of genocide and crime against humanity. He will speak about 1935, the year when James MacDonald resigned from his office of High Commissioner for Refugees of the League of Nations, at a time when there were no rules of international law. And then Alexander Aleinikoff, who is former UN Deputy Commissioner for Refugees and currently at Columbia University, will speak about revitalizing the international response to forced migration and drawing, I would say, a landscape of the current state of affairs. And then from then, Ayelet Shahar will have the difficult task to comment on these very different papers, but if we reflect a bit further, and I've had the privilege to read the papers, we can see in fact that they are focusing on the same issue. Has the situation improved along the century and in the beginning of this 21st century or not? I'm not sure that our speakers have exactly the same answer to this question, but now I will give them the floor so that you can also have your own opinion on this. So Philippe, you have the floor.
Thank you very much, Hélène, and thank you to the organizers. I'm bowled over and struck by the extraordinary richness of this event, participants, subject matters. It really is a testimony to a very vibrant area. As Hélène has said, I'm going to go back 80 years, and I'm going to talk about an issue of movement and migration That, of course, is not disconnected from other events that took place in this city, and really posing a question which I can't even begin to answer. Namely, we were then at a time in which there were no international rules dealing with the kinds of issues that this panel is going to address. Today we have a system of rules, and we are bound to ask ourselves the question, what has actually changed? I have spent much of the last 7 years immersed in the period 1914 to 1946, exploring the lives of 3 men. 2 of them were prosecutors at the Nuremberg trial, and 1 was a defendant. The prosecutors, or on the prosecution teams, were Hersch Lauterpacht, who was promoting the concept of crimes against humanity and the protection of individuals, and Raphael Lemkin, who worked not, as Lauterpacht did, with the British team, but with the American team, promoting the concept of genocide, the protection of groups as opposed to individuals. They shared a number of things, although they had strong differences in respect to the question, how does the law best protect the rights of individuals, minorities, and groups? And of course, both of them were themselves refugees, having moved from their place of origin in Galicia, in what was part of the Austro-Hungarian Empire, and eventually became Poland, and is now the Ukraine. And the answers they gave to those questions have thrown up a number of further questions which I've been exploring. They found themselves on the other side of the courtroom, the famous courtroom 600 in Nuremberg, with a man who may once have been in this very room. His name was Hans Frank. He was Adolf Hitler's personal lawyer from 1928 to 1932, and eventually became Governor General of occupied Poland. And he had a very different conception of the rule of law, the rights of individuals, and the rights of groups. So immersed in that period, and invited to address the subject of migration and movement on this plenary panel, I feel firstly somewhat of an imposter, because I am not an expert in the law of refugees or migration. I come to it as a general international lawyer with a keen interest in matters historical. And I settled on one tiny story that emerged in all of the research that I did that struck me as interesting, possibly, in illustrating an experience that took place in the autumn of 1935 and concerned, as Hélène has said, the letter of resignation of the Commissioner for Refugees under the League of Nations, as the entity then was. And in particular, the question which dominated a vibrant debate between a small number of individuals in drafting that letter as to the relationship, if you like, between politics and law. The reason I've taken that topic, and the reason I felt it was not inappropriate to take that topic, is that even with my limited background in issues of refugee status and migration, and paying obvious attention to the recent EU-Turkey agreement and the manner in which it seems to have bulldozed through many of the EU's own rules on migration and refugee status, as well as aspects of the 1951 Convention, was that that agreement also raises fundamental questions about the relationship between politics and law, between pragmatism and principle. And so I want to use this episode and this story that I'm going to share with you, which probably many of you will not have come across, although I express my deep appreciation to Professor James Loeffler, who was the person who first introduced this story to me. And perhaps in the discussion we can then ask the question, to what extent, even from this tiny experience, can we draw lessons that may be worth thinking about. The paper, or the speaking note that I've prepared, begins by raising questions about context, and in particular the situation that pertains right now in Europe concerning a very large number of migrants and refugees, economic, political, and other, coming from various parts of the world, including, of course, Syria and Iraq and Afghanistan. The arrangements that have been put in place in the spring of this year raise, I think, the most serious questions as to the compatibility of those arrangements with existing international obligations, and highlights the acute but delicate relationship between political realities and constraints on the one hand, and our sense of a commitment to the rule of law, including the rule of public law and international law, on the other. It's often said in the media that the issues we face are today without precedent. I don't think that is right. I don't think it's without precedent in terms of scale, and it's certainly not without precedent in terms of principle. The episode within the episode to which I want to refer concerns the efforts of a young American academic, Professor Oscar Janowski, a historian, to prepare an annex to the letter of resignation of the League of Nations High Commissioner for Refugees, James MacDonald, as I mentioned, in the autumn of 1935. Janowski wanted to include in the letter, as an annex, a far-reaching call declaring the rights of all individuals and minorities, going significantly beyond what international law at the time provided for. James MacDonald had decided to resign in October 1935 as commissioner in the face of what he called a total political failure at the League of Nations to support his efforts to safeguard non-Aryan refugees, both Jewish and other, resulting from the implementation of policies of discrimination and expulsion adopted by the recently elected National Socialist government in Germany. MacDonald recruited a number of individuals to assist him in drafting his letter of resignation, almost exclusively from the United States and Britain. A particularly contentious issue arose with regard to the question of what rights, if any, did the refugees have under international law, and what obligations, if any, did states have under international law, including the right of what MacDonald called humanitarian intercession, to intervene, to protect the well-being of humans who were under threat. I often remind my students that 70 years in international law is both a short and a very long time. There were no rules of international law as at that period which prohibited a state from imprisoning, torturing, enslaving, killing, disappearing its own nationals as a matter of international law. That, of course, only changed after 1945. So we have to immediately put ourselves in a different mindset. And you have to imagine yourselves in this room back in 1935 as to the paucity of international rules that existed. The content of the annex, what to put in it and what to exclude, turned on sharply competing considerations as to the balancing between the articulation of legal principles, if not rights, on the one hand, and deference to matters of political risk on the other. As Janowski put it in his unpublished memoir, and I quote, "There was a good deal of discussion as to whether MacDonald should or should not make such a statement, whether the lot of the persecuted non-Aryans might be worsened by such a statement, whether the Nazi government should be provoked, whether the well-disposed Western powers should be troubled with a small matter like human or minority rights." End of quote. You can take those words and you can superimpose them almost word for word, not in relation to the particular government or the particular individuals, I think, with the current situation that we face today. Just to pause momentarily, we all know that last week the German parliament voted to characterize the events, the killings by the Ottoman Empire of the Armenians as a genocide, which caused the immediate recall of Turkey's ambassador to this country. So offensive was it deemed to be. And the executive in this country is obviously principally concerned not with the issue of principle, but with the impact of such a characterization by the German parliament on the future prospects of the EU-Turkey agreement. That is at the heart of the real concern. So there is a real politique here, which was as live in 1935 as it is today. MacDonald was an American academic, an analogy with our speaker who will follow me, Alex, who taught history not at the University of Indiana and who served as chairman of the Foreign Policy Association in the United States. In accepting his position as High Commissioner for Refugees, his job was to negotiate and direct the international collaboration necessary to solve the economic, financial, and social problems of the refugees. He resigned within 2 years of being appointed, and he resigned, as I said, because of the total lack of support from governments across the board. He wanted to draft a resignation letter that would shock governments and public opinion into action. And he recruited not only Oskar Janowski, but a young American academic called Melvin Fagan, who were both delegates of the American Jewish Committee. And he involved also their British counterparts at a more senior level, influential intellectuals who included amongst the group Professor Norman Bentwich and Professor Hirsch Lauterpacht, who at that time was at the London School of Economics. Internal differences meant that the project started as an American-led effort. Janowski and Fagan determined the scope of the project as being to produce an annex that was a scholarly and forceful memorandum which called attention to the plight of the refugees, the burden of Nazi policies, and the legitimacy of international concerns. And in particular, they wanted to identify precedents to stop this kind of behavior from proceeding. Should the letter contain an annex, and in particular, should the letter contain a statement about the rights of religious and racial minorities, which might be a part of a so-called Bill of Rights in relation to these displaced persons, but also an indictment of the persecuting country. In preparing the annex, the first drafts were written in the United States. Janowski devotes a full chapter of his memoir, chapter 17, which he describes as a day-to-day record of the MacDonald letter of resignation, and it is well worth reading. It recounts a period of just a few weeks in late 1935, reconstructed from memory, good and reliable memory, from MacDonald's diaries, from Janowski's diaries, and from the correspondence which is preserved. In America, as the project started, American academics supported a far-reaching call for an indication of the rights of those who were refugees. But the British Jewish community, which was then consulted, did not support that approach and called for a more pragmatic approach. And in the context of that, Janowski's views evolved. There was, Janowski writes, a good deal of discussion as to whether MacDonald should or should not make a statement proclaiming the rights of these people. And there was a real concern that their lot would be worsened by focusing on these matters of principle. But Janowski decided that what really was needed at the moment was using also the media and the publication of the letter to galvanize people into action. He did not believe that the League of Nations would somehow be roused into action. He just wanted to deter mass acceptance of the kinds of policies that were being promoted. And of course, there's a direct analogy here with the locking the doors policy of certain countries in the European Union who find themselves in an analogous situation in a certain sense. Janowski summarized his view in discussions with MacDonald as, and I quote, a plea to the conscience of humanity. It was, in essence, a call for a rule of law, one that would wait another 15 years before it was properly articulated. In September and in October 1935, they prepared a lengthy draft annex, confronted with what Janowski saw as a lackadaisical and often downright indifferent attitude of an appreciable number of academics to these matters. They left the United States at the end of October 1935 with a full draft. They arrived first in Geneva, and then they flew to London, where they arrived on the 2nd of November 1935. MacDonald thought by then that he had a strong support for the position taken by the American academics for a strong indictment of the policies and of the failure to act. The British, by contrast, counselled caution. By mid-November, Janowski had won his initial skirmishes and persuaded a number of the British academics to incorporate the draft annex into the letter in full, as the American scholars had wished. That was until Bentwich and Lauterpacht turned their fire on the project. And just to pause here, what you've got in issue is a pull in competing directions, a pull towards principle on the one hand, and a pull towards pragmatism on the other hand. A pull towards law on the one hand, a pull towards politics on the other hand. Matters came to a head on Monday, the 18th of November, 1935, what Janowski describes in his document as a full dress conference held in Lincoln's Inn. Amongst those present was Hirsch Lauterpacht, and the reason I focused on him is that he played, obviously, at least in the research I've done in the last 7 years, a very singular and significant role in the emergence of the Universal Declaration on Human Rights with his publication of A Bill of International Rights of Man 10 years after these events. And so I'm very struck by the difference of position and his evolving views in that 10-year period. Janowski's writings on him are interesting, and I'm quoting just in terms of giving you a flavor of what was at stake. Janowski did not take well to Lauterpacht. A brilliant man on the rise, he noted, but also a bit overbearing, a man of self-importance who pontificated like a judge when he should be advocating a cause. In particular, Lauterpacht caused great offense to Janowski because he declined at all to work with one of Janowski's graduate students, and this fact prompted a tirade about Lauterpacht's pomposity and arrogance. Unquestionably a brilliant authority on international law, Janowski writes, but a man whose attitude was consistent with the libelous stereotype of the Galicianer, who dismissed the views of others using steamroller tactics. Fidgety and impatient during meetings, he showed that he was no gentleman and became patronizing and angry if he didn't get his own way. All of this is, of course, written with the benefit of hindsight. Janowski lost to Lauterpacht. Lauterpacht crushed the effort, and Janowski takes it out in a memoir that he hoped to publish but never did publish. Nevertheless, Lauterpacht somehow sensed that he'd taken things too far, that he had misbehaved in calling for a pragmatic approach, calling for an approach which did not provoke the German government to go even further than it had already gone, and to subsume issues of principle to the greater good, namely the well-being of the individual refugees who by now numbered tens, if not hundreds, of thousands. Lauterpacht did write a grudging letter of apology to Janowski in relation to some of the things he had said. "I love to see my own work torn to pieces," Lauterpacht writes. "When I submit it to criticism, I may be committing the mistake of thinking that others approach things in the same way." At that point, the rubber hits the road. Lauterpacht stands firm and says, no, we will not issue a declaration of international precedents to safeguard human rights, even if we think such a thing may be essential. We will be pragmatic and proceed in that particular way. And Lauterpacht, to cut to the chase, manages to turn around the entire process. And at the end of the day, the annex is stripped of any of the material that the American academics have wanted to put in relation to using the idea of legal rights and individuals for legal rights and obligations in respect of the rights of individuals, minorities, and groups to marshal public opinion and turn around the behavior of one government and influence others from acting in the right way. And rereading this material, it again struck me, and we'll hear from Alex and Ayala and Hélène as to whether or not there are or are not parallels. It did strike me that there was at least some point of parallel in relation to the situation that we now face in the European context on the issue of what to do with our refugees. Lauterpacht simply called for and got what was Section 2, entitled Precedents of the Annex, to be eliminated in its entirety. And he managed to persuade James MacDonald to move in that direction, and it was indeed, on the 8th of December 1935, stripped in its entirety. When MacDonald's letter was published, and it is well worth reading the letter, he sent it to the Secretary General of the League of Nations on the 27th of February 1935. 3 days later, the New York Times devoted a front-page feature to the story of the letter and the resignation and the issues that it raised. Commissioner for Refugees quitting, asserts 500,000 in the Reich are being crushed. And a similar article was published in the Times of London. No mention was made of the discarded elements in Part 2. What you have here is a conflict, in essence, between Janowski and Lauterpacht. And Janowski was incandescent. As incandescent is the head of Amnesty International, for example, and Human Rights Watch in relation to the EU-Turkey agreement that was adopted just 3 months ago. Incandescent about the fact that legal principles put in place in the 15 years after this incident took place were being sacrificed in the name of political pragmatism and keeping the European Union together. Lauterpacht's position interests me because, of course, just 10 years later, he adopted a rather different approach when he published an international bill of the rights of man, seeking to ground that enormously important academic work, really the first modern book on human rights as we know it today, in a system of rules which he was able to glean, if not in positive public international law, then certainly in general principles of law and in natural law, which he was not willing to do 10 years earlier. So I'm curious about what happened in that intervening 10 years in relation to Lauterpacht's own thinking on these issues. It's also worth mentioning that at the same time that this was going on, there was a proposal in 1935 to refer the whole question of Germany's treatment of refugees to the Permanent Court of International Justice by way of an advisory opinion, and Lauterpacht sought to crush that effort as well. In his words, such an effort was inadequate, impracticable, and highly dangerous. It would give rise to the very opposite of the intended consequences of those who were its proponents. In other words, pragmatic Lauterpact is concerned that by provoking the government that is doing so much to cause mayhem, you will give rise to an even greater evil than the one that you currently face. And that, again, seems to be the situation we find ourselves in right now. To close, just simply by referring back to events of 80 years ago, so closely connected to this city, it's become very clear to me, having immersed myself in this world of the period 1914 to 1946, that the legal acquis that we believe to be immutable today may not be quite as immutable as we think it is. A world was swept away in 1939, and the question that arises is whether the world that was put in place after 1945, and in particular in 1951, can withstand what is apparently on the cusp of happening. I say this as a British national who is deeply committed to the United Kingdom remaining in the European Union. It feels almost like a personal affront that probably next week the United Kingdom will vote to leave the European Union. That, I'm very sorry to say, is the position as things now stand, even before yesterday's deplorable killing of a member of Parliament. And so I think, as we look at the issues that I think Alex is now going to talk about, it is useful to go back to another period and ask ourselves, what might we learn from those lessons from the past, and how secure is the structure that we have now put in place? For my part, I think that there is no room for complacency and every reason to be somewhat anxious about the direction we may be taking, not in relation to the subject that I've just addressed, but more broadly, the legal and institutional framework that has kept the peace on this continent for the last 60 years. Thank you very much indeed.
So now it's for Alexander Aleinikoff to take the floor. And so.
Just have to sit. Okay, so I'm tempted to throw my entire talk away and just talk about what Philippe has said. I'm not at all sure about the distinction between politics and principles. I'm not at all sure whether I'm on the side of principles or pragmatism. I'm not at all sure the system is falling apart, but I am quite sure that a Eurocentric view misses most of the interesting questions about what's happening in the refugee regime today. And as I look around this room, which is fairly monochromatic and fairly European and North American, I think we've really got to step out of that model and take a look at the rest of the world, where 85% of the world's refugees live in bad shape, and to distinguish the movement from Nazi Germany, which were people moving from a country of persecution to a country of first asylum, from the movement from Turkey to Europe, which is a movement from the country of first asylum to a country of second asylum. That's all maybe for the discussion to happen, but let me now talk about what I'm supposed to talk about. That was just to get you a little interested, I suppose. So you have seen the pictures that Philippe referred to indirectly, and they're graphic, they're heartrending. The numbers are beyond comprehension here, not just in Europe, but worldwide. 60 million people displaced from their home because of violence and conflict. 20 million of those are refugees, 40 million displaced inside their countries, highest number since World War II. Emergencies pile on top of unresolved questions. When 150, 200,000 Somalis fled their country in 2011, they arrived in places where there had been Somalis for 20 years who had not been able to go home because of continuing conflict. This is the new normal. One for which I think the legal instruments and institutions established just after World War II are no longer fit for purpose. So in a way, Philippe and I are actually hooking up here in terms of a time sequence, and I'll talk about the post-World War II period, why I think the structures there don't fit the current moment, and what maybe we should do about that. It's surely the boats arriving in Europe as well as the boats sinking in the Mediterranean that have occasioned the current calls for that something must be done, the system must be changed. But I want to say that the threats that overwhelm the international system began long ago, and the most intractable parts of the problems are not present in Europe. Those are fairly easily solved if you had an EU that was willing to do so. But it's in the developing South, where, as I said, the vast majority of migrants, forced migrants, are now located. So I want to talk briefly about the core elements of the international forced migration system, how it's developed, what the challenges are, and then suggest a few policy and institutional reforms that may save the system or try to get it ready for what's coming, which will only be more of the same or more than more of the same. My overall thesis is that we lack the necessary international architecture for protecting refugee rights and helping them rebuild their lives. And in fact, more than that we never really had an effective international architecture. That's maybe the surprising part of this, the counterintuitive thought. I mean, we have a 1951 Convention on the Status of Refugee, now signed by more than 140 parties. The year before the convention was actually adopted, UNHCR was created. It's been around for more than 60 years. It has a budget of $3 billion, a staff of 9,000 people. It works with hundreds of partners around the world. How can I say we don't have an international architecture? Well, it seems that our responses continue to be surprisingly ad hoc to refugee emergencies. We seem to reinvent the wheel or invent a different wheel with each crisis. So let me try to set that argument up for you. The international refugee regime, and here I'll switch metaphors from architecture to regime, by which I mean legal norms and practice-based norms as well. The regime that's been set up is in the 51 Convention was a partnership of states, member states to the Convention, and with UNHCR. And it provides a very important definition of refugee and a robust set of rights. The Refugee Convention is a major human rights convention. Central to those is it's called the right of non-refoulement. You can't be sent back to a country that will persecute you. But also a long list of other substantive rights: freedom of movement within the country where you're recognized as a refugee, a right to work, protection of labor laws, freedom of speech, freedom of religion, access to education. As I say, a robust list of rights. And in some ways, I see the convention as in conversation with or an answer to Hannah Arendt's famous argument in Origins of Totalitarianism, published the same year the convention is adopted, 1951, where her argument was that human rights meant nothing at the time they were supposed to mean most for stateless people, and that unless people are members of a society, their human rights cannot be protected. They must be citizens first, and then the human rights can be protected. The convention and the establishment of UNHCR answers that in two different ways. First, states come together and agree to respect refugee rights. This is Philippe's point, is there was no law before this. There was an earlier High Commissioner, but there were no agreements among states to respect refugee rights. They sign on to this convention saying, we will respect rights. And secondly, the recognition of what's called in the business a durable solution, which means, a la Arendt, reattachment to a political society, either return to your home country, local integration in the country that gave you asylum, or resettlement in another country. The idea there being that you needed membership in a state to have secure, full set of rights. But the convention stopped short in a number of important ways, and it really was it was a compromise, and remember when this is written in the 50s, really just the very birth of the human rights movement, a compromise between state sovereign control over its borders and over immigration, and the human rights of refugees and global humanitarianism. And look at how this plays out in the convention. So first of all, there's no right to enter a country to apply for asylum. There's only a right not to be returned. There is no international enforcement structure for the rights established. It's left up to states to enforce the rights. So there's no refugee court. There's no treaty body to monitor compliance as there is with the later international conventions. There's no international structure for producing solutions. When refugees flee across borders, what should happen next? How do we get them home? How do we get them elsewhere? There have been a set of ad hoc arrangements that have come up, but there's no structure for that. In fact, the convention, after establishing a long list of rights, says, and by the way, states may want to think about naturalizing refugees, but it's not commanded that states do so. So there's no, in the business we call this, there's no international burden sharing or responsibility sharing structure or arrangement. And there are exceptions to the conventions. People convicted of crimes, people who are security risks can be refulled, can be returned to their countries, even if they will face persecution, or they can be sent elsewhere as well, so long as they're not sent home to the country they fled from. Now, even with these compromises in the convention has grown in practice. So even though the convention definition today is seen as a fairly narrow definition, persecution based on race, religion, national origin, membership in a social group, or political opinion, or the 5 so-called on account, you have to show that you'll be persecuted on one of those 5 grounds. In fact, most refugees never go through refugee status determination adjudication to see if they meet those qualifications. Why? Because the world now treats anybody who flees across a border into another state, if they're fleeing conflict and violence, treats them as a refugee. And what UNHCR does, or states do, is they register people, but they don't adjudicate the claims. And they're seen to be refugees. So for the 4.5 million Syrian refugees, there's been virtually no refugee status determinations made in any of the neighboring countries. It's only when they come to Germany, the United States, Hungary, other places that these determinations are made. They're considered refugees in the region. And that's huge. That's a major expansion of the convention. But it's interesting that the neighboring countries to conflict all accept people to refugees. It's the secondary states where the flows go to that get much more restrained in their definitions of the rights. As the definition has grown, so have the resources devoted to refugee relief has grown. So UNHCR's expenditures, listen to this, in 1971, 20 years after the agency established, the agency's budget was $9 million, $9 million. 10 years later, 500, 1992, 1 billion, and now well over $3 billion. So huge growth in resources, and most of this is an assistance to refugees in the developing world. If you put all these pieces together, this is how the system basically works now. Refugees, a crisis occurs in a country. People flee across borders. They're registered by UNHCR or by the state into which they flee. They're given emergency care, tents, blankets, food, water, and after a while, that care continues into the next year, and the situation is normalized, in the sense that maybe the medical care gets a bit better, a few schools are built, but it's still considered humanitarian assistance that goes on forever and ever and ever. And this is what produces a situation of dependency for refugees, or worse, as the emergencies crop up elsewhere, declining resources devoted to refugees, which means that they are in worse and worse conditions. The hosting states vary in degrees to which they include refugees in their local processes. Resettled refugees in Germany, in the United States, elsewhere, get all the rights of nationals of other states and many of the rights of citizens. But many of the refugee hosting states in the immediate areas do not grant those rights, and I'll say a bit more about that in a moment. So in this manner, the refugee situation stabilizes and can continue for years or for decades without much change in program. Refugees are restricted, many refugees are restricted to camps. Only about a third of refugees are actually in camps. I think the images of refugees in camps, Lebanon is a country with 1 million, a population of 4 million, and a refugee population now of 1 million. Extraordinary. There's no refugee camps in Lebanon. They're all living in urban areas or in settlements or other places. But in camps, Refugees, as I say, become dependent. There aren't many livelihood opportunities, ways to make money. Outside of camps, they live in marginalized places, often not able to assert their rights under local law or certainly their rights as refugees. So even without the Syria crisis, the international refugee regime was facing major challenges because of these emergencies in Central African Republic, Mali, Nigeria, South Sudan, Ukraine, Yemen, places we don't hear much about because we're so fixated on the flow between Turkey and Greece. Once people started moving from the Syrian refugees began to move to Europe, it became impossible to ignore. And we had to then take a much closer look at the system we had built. Now, let me say briefly in a couple of ways the way I think the system is broken, and then end with a few suggestions. Being a refugee means that the usual bonds between a state and its citizens have been sundered. The state is no longer able or willing to provide the physical safety, political membership, social benefits, and the rights that are generally accorded to citizens of a state, to whatever degree those rights are afforded. The international refugee regime, as I said, was established to offer surrogate protection to refugees. Now, interestingly, the goal of the system, it's to end refugee situations, but it's not to end them by intervening in the state that caused the refugees. It's not to produce regime change in the sending countries or any other kind of intervention. Rather, it's to ameliorate the harms of exile and displacement. And for that to work, four things have to be in place. One, there must be asylum space. That is, refugees must be able to get into another country. Two, they have to have rights once they get there so that they can take care of themselves and their family and begin to rebuild their lives. Third, there have to be solutions to refugee situations. They can't go on and on and on and on, like Afghan refugees who fled with the Soviet invasion in '79 are still 1 million refugees in Pakistan and 1 million refugees in Iran. And fourth, there needs to be international cooperation. There needs to be this international burden sharing to work on solutions. Each of these elements is under dramatic pressure today. On the denial of access, as I said, most states bordering countries in conflict leave their borders open. The states bordering Syria now have begun to close their borders. They've tightened their borders dramatically. They took 4.5 million. They said till the rest of the world helps, we're not going to take too many more. But people fleeing these other countries I mentioned, if the refugees fleeing Mali could enter Niger and Algeria, Burkina Faso, and I can go around the world and talk about the various countries. But it's the states that are not contiguous to the refugee-producing countries that have adopted policies of deterrence. The EU response to Syrian refugees, the United States response to Central American refugees, Australia's response to boats coming, Israel's building of a wall and opening a detention center directed at asylum seekers from North Africa, and non-EU European states like Macedonia building a literal fence between Macedonia and Greece. So on the access side, it's a mixed record, but in the non-contiguous states, not a good story. Crucially is on the denial of rights. As I said, this convention is a dramatic human rights treaty, and yet the rights are routinely denied. First of all, a number of major refugee hosting states have not signed the convention. While 140 countries have, Thailand, which is a major hosting state, is not. Pakistan has not signed it. Lebanon and Jordan are not signatories to the convention, although some non-signatory states actually do a better job of recognizing rights than signatory states. But signatory states generally don't recognize the rights of refugees. Most refugee hosting states do not give refugees the right to work. They say they'll be competing with locals, but that's a right in the convention. Many don't let kids into school or charge fees that essentially keep them out. Many discriminate on provision of medical care and other kinds of licenses and work in the professions and the like. So there's routine denial of refugee rights currently in the world. And as I said, the recognition of rights was absolutely crucial. The idea was never to have camps forever. The idea was to get refugees in a country, give them rights, let them pick up their own lives while they're waiting for a solution. Third, and equally serious, is the lack of solutions. We have the new normal now, the new rule, not the exception, or what UNHCR calls protracted refugee situations that go on for more than 5 years. The vast majority of refugees, and particularly when the Syrian refugees passed the 5 earmark shortly, are in situations of long-term displacement. Repatriations are very low because countries in conflict, the conflicts aren't resolved. Resettlement, maybe 100,000 a year. There are probably more children born as refugees every year than resettled in other parts of the world. Local integration, not permitted by most states for fear of competition with locals, and also the view by the hosting states that this should be a global problem that the world takes a part in. So a real lack of solutions, and we have a situation never anticipated by the Convention of refugee status lasting decades. And lastly, as I've said, a lack of an adequate responsibility sharing structure that would get the countries of the world together. I could mention the European situation. I'm going to skip the specifics of Europe, except to say that the EU, I think as I already said, has dramatically mismanaged it. The EU-Turkey deal is quite likely to fail, and it was the wrong deal to begin with, and we can maybe have questions about that later. Lastly, the other way things have really gone sour is in the rise of xenophobia that makes state protection of rights and achievement of solutions difficult, not just in Europe. Would have been unimaginable a few years ago that a candidate for a major political party in the United States would call for a halt of all refugee admissions into the U.S. from Muslim countries, or that 24 governors in the United States, of states in the United States, would attempt to bar refugees from entering their states. A court yesterday invalidated that in Texas. We'll see how far that goes. Together, these elements have coalesced to seriously undermine the ability of the international refugee system to deliver on its basic goals. And this is how these all work together in a vicious downwards cycle. Denial of access means people will be forced to reside in unsafe places. Denial of rights coupled with a lack of solutions produces refugee dependency. I've called this, things I've written elsewhere, the second exile. The first exile being when people are forced to flee their country. The second exile being in hosting states where they're not included in the usual social benefits, right to work, economic system of the country. And a lack of an adequate responsibility sharing framework contributes to all these challenges because states are less likely to be willing to be countries of first asylum if they don't think other states are going to eventually help them out, or to recognize rights if other states do not contribute to refugee assistance. And a system seen as unresponsive and out of control fans the flames of xenophobia, which in turn restricts political will to expand funding, resettlement, and other programs aimed at ameliorating the situation. Okay, do I have 5 more minutes? Okay, what can we do about all this? Just getting the system to work as it was supposed to work would be dramatic. It would mean maintaining borders that are open to asylum seekers and that the principle of non-refoulement is rigorously respected. It would mean an increase in funding for refugee assistance. It would mean making significant progress on solutions, launching anti-xenophobic campaigns where needed, and I think initiating a legal campaign to enforce refugee rights around the world, which has been surprisingly absent given all the human rights lawyers around. This has not been taken up as a human rights issue, and I think it should be. But the problem is, the situation is going to get much worse. As I said, we have these continued flows on top of existing situations. The flows of people across borders because of natural disasters and climate change will dwarf the flow from conflict in years ahead. We have no system for handling that. So I think 3 things have to happen. I'll be very brief on these. The first I would call programmatic change. What this means is that we can no longer simply view refugee situations, particularly these long-standing situations, as humanitarian crises. Humanitarians cannot solve these situations. They can't make peace in the countries at home, and they can't produce the kind of inclusive policies that are necessary to end what I've called the second exile. What has to happen here is that development actors in the world, where all the big money is, the amount of money spent on development around the world is about $200 billion a year. The amount of money spent on humanitarian relief is about $25 billion a year. So much more money into development. the development agencies have to begin to see displacement as an area for their involvement. This is beginning to happen. The World Bank is now moving into displacement. It's a game changer and hopefully will be a fulcrum for change. But the system has to change to move beyond humanitarianism to a much more comprehensive approach to refugees. That has to happen at the ground level. Secondly, legal and policy changes. I think it's probably time to think about a protocol, a set of guidelines that covers people who are forced to flee because of conflict, who don't meet the narrow definition of refugee. UNHCR has some clever arguments about why those folks meet the definition. Not everyone's convinced. No one wants to reopen the convention definition. People fear what would happen, but I think there could be a legal move for a new kind of protocol or other language that would recognize this. And perhaps eventually we'll have to do something about pushing forward for people forced by climate change to move as well. There will need to be an international order that deals with that may be a little further down the road. And then thirdly, institutional and structural changes. And here I talked about at the beginning the absence of an international architecture really to solve refugee situations. It's not a good time to call for a new UN agency. And in fact, the problem needs to be solved outside the UN because the UN doesn't control the development resources. Most of that's done outside the UN. If it's simply left as humanitarian, the UN can respond, but it needs to go beyond. So what I'm beginning to think about and would put on the table here is what I would call a global action platform and fund for forced migration. It's a mouthful. What I mean by that is a multi-stakeholder organization of donor states, hosting states, multilateral organizations, perhaps private sector, perhaps foundations, that would put together a lot of money and a set of guidelines for programs and then fund change in the field for a new kind of programming in the field, bring together states for major solutions conferences, bring the private sector in where I think investments are possible in refugee hosting areas. I don't have time to go through all these possibilities, but in short, this action platform and fund would be, I hope, the way to move us to a new way of thinking about refugee protection and refugee support. It's the reason I raise it here and why it might be of interest to this crowd is because I think it is a new way of thinking about international public law. It's not a UN agency. It's not owned simply by member states like the WTO or like the World Bank. It does have some analogies in Gavi, which is the Alliance for Vaccines, and the Global Fund for malaria, HIV, and tuberculosis. But it's a structure that would be a mixed structure, a structure that would incentivize behavior rather than command it. And I see it as part and parcel of the more horizontal, transnational way we are beginning to think about public law structures into the international sphere. And I think it would merit additional public law scholarship. So let me just end with this. We can get lost in lawyers' talk about norms and structures, but in the end, the crucial thing are the 60 million displaced people, and I'd say it this way, refugees' lives matter. Whether they're trying to come across the Mediterranean, or trying to get into Kenya from Somalia, or trying to get to Australia by boat, or trying to get to the United States over the southwest border. The system we set up after World War II could have worked. It hasn't. It is not fit for purpose at the moment, and we can continue to stumble along, or we can begin a process of serious operational, legal, and institutional reform. Thank you.
So thank you very much, Alexandra. Now we will have the comment of Ayelet Shahar. I'll just introduce briefly her to say that she's currently director of the Max Planck Institute for the study of religious and ethnic diversity. So we are really at the heart of the topic, and that she, among other things, works intensely on immigration law and on regimes of human mobility and equality. So I think that we couldn't have a better commentator for these two papers. And I think the question is, have things changed over the time? You have the floor, Ayelet.
Oh, wonderful. Thank you so much. It's such a pleasure to be here and to look around in this large auditorium and to see so many friends and colleagues and scholars, you know, from different levels in their careers, and all joined here for this first plenary panel for ICONS 2016 annual conference. So it's a real pleasure for me to be here. And fittingly, when we talk about refugees, human rights, the new architecture, potentially, of the international migration system, the history, troubled history, the potentially, as we heard, troubled future, I think being here in Berlin, in Humboldt University, is quite significant. The history bears heavily here, obviously, on precisely these very topics. So in terms of my duty, I actually have a difficult task because I want to connect the two papers that you heard, and they're very different in terms of their approaches. I'll first draw two distinctions between the papers, and then I'll try and provide three different ways or approaches to connect the two papers and the messages that they convey. But before I do so, I just want to say it's such a pleasure and honor to comment on these two particular scholars, because as you know, both Alex Aleinikoff and Philip Sands are some of the leading authors in the world, really leading thinkers about questions of citizenship, migration, human rights, genocide, of course, the question that is most pressing in terms of our panel today, the questions of refugees, their status, the potential rethinking of the current international system. So this is by way of my introduction. So let me now try and draw two distinctions between the papers. And as I said, later on, I'll try and connect them and also reflect a little bit on their arguments per se. So one way, obvious, to think about the relationship between these two papers that we heard is through the temporal timeline. That is, Philippe asks us to look back. And it's not a very distant past, it's the past of the modern international refugee system. And he actually wants us, usually when we think about the past, we would think about 1951, the moment that the convention was born. But Philippe asks us to look back into an earlier period. He focuses specifically on one moment, 1935, in the discussion of MacDonald's resignation letter and how to frame it. But it's significant to actually do this move because it requires us to think about what has actually changed and what has remained the same. So to some extent, the timeline here is actually very significant for our discussion and in terms of thinking through the current and future challenges. So that's one way to think about Philippe as asking us to look backwards, look into the past. And Alex, as we heard, talking about the failure or the current new normal and the urgent need to reimagine or re-envision the international system in terms of how it deals with refugees and other displaced persons. So that's really calling us to look forward. So that's one way of thinking about the two papers. The second way to distinguish between them is just the kind of work that they do. That is, as you heard, Alex really focuses on the legal institutional angle. So both in terms of analyzing the kinds of problems in the current system, its design, the current failures, and potentially the reconstruction that is trying to think about new, different alternatives, ideally better alternatives than what we have. And with Philippe, we're actually looking much more at the historical, and the analysis is much more on individual actors, how they might have tried to affect the very serious dilemmas and concerns that they face. So these are the two distinctions. Now let me try and draw several connections or points of potential meeting points between these two papers. So the first one, and I think is the deepest, hardest question that we have in this field, is what I will refer to as the normative. And when I say the normative, here is what I'm referring to. And again, the papers really bring these tensions to the fore. And we heard, especially in Alex's paper, that the international regime or international refugee protection structure that we have actually puts a lot of burden on states to do a tremendous amount of work. They are the ones who have the responsibility to define who fits under the category. It's a general category, but each state has its own jurisprudence. They are the ones who are supposed to provide rights to refugees. In some cases, they're supposed to provide either short-term, as we heard, short-term that are almost eternal kind of solutions, or really permanent solutions which are designed as such. So on the one hand, states are the good actors. They are the ones who are supposed to provide the safe haven and potentially to address the international plight of refugees. On the other hand, we know, and the convention does not challenge this, we know that states are the ones who still have the sovereign authority to control mobility. They have, in theory, or under immigration law, they have actually the legal right to define who among the non-members who wish to enter may come in. And this is a striking point, which actually Alex again mentioned in his discussion, not just in the paper, which is to mention that the convention per se, the 1951 convention, does not allow refugees a right to enter. Think about it. It's striking. People are escaping persecution, and they're not granted a right to enter. All that the convention does is to say, well, if you've entered, you cannot be removed. That's non-refoulement. But first you have to enter. So it's a difficult basic paradox and tension that we have in the current system. And both of the papers in different ways really point to this concern that we have. And it's partly an institutional concern about the centrality of states, despite the fact that we have many, many, many other actors. Still, the burden falls on states. And on the other hand, in terms of other aspects of our international law, domestic law, public law, states are the actors that are permitted to control mobility. So it's that deep tension which I find in both papers, and it's not just in the papers. This is a real concern that we have in the real world around us, how to address this question about the role of states. Now add to that the point that, again, both papers bring out the question of politics. So we can talk about law and legal rules and principles, but in this area, we find that political considerations are so front and center, both on the international arena and also domestically. So if states are the actors that need to provide protection to refugees, how do they need to deal with a domestic population that might resist that? If we think about democratic principles, they should listen to their own demos. On the other hand, if they are bound by the responsibility to protect, how do we address this built-in tension? Now, I think not addressing it is the worst solution, because then we do get to the xenophobic, we get to the anti-immigrant, anti-refugee kind of responses, the populist right wing that we're seeing. But I think this is a difficult issue that we need to give more consideration to. That is, how do we address this basic tension, given that these are the actors that we have asked to carry their responsibility. So that's really the first point, and it's normative, and it's also partly structural. It's structural in the sense that if we want to re-envision a new and better system of protecting refugees, then we need to think about which level, which actors could do this, what's the best institutional structure, which human rights have to be addressed by whom, and how are we going to redesign this system. So that's the first point. The second point refers to actors, and I know we are under time pressure, so I'll just mention it. I'm not going to develop it. But here, as in many, many other fields of public law today, the question of which actor, which level of authority should have which responsibility is of course very, very present, and it's very close to us, not just in Europe, but worldwide. So should it really be states? Should we give more weight to international organizations, to NGOs, to civil society, mixed solutions, Alex, as you mentioned, the private-public kind of potential partnerships, the global, is it the Global Action Platform? Okay, I wasn't far. Global Action Platform and funds. So what level of analysis, where are we going to really put the weight in terms of actors? And I think that's a very, very central question, again, that the two papers bring out, but also that we face in the real world around us. And again, this is a difficult question because if we're not just looking at the current, but trying to take on Alex's challenge of the new normal and envision a better future, then we need to think about who has the responsibility to address, ideally prevent, and more realistically respond to forced migration pressures and trends and mobilities. So again, this is a real challenge, and this is a perfect room to actually throw out this challenge, because people here are thinking about these issues all the time. You might just now apply them more directly to questions of refugees in this context. So that's the second point. I have my own thoughts about the overemphasis we put on states, and also the notion that we have that that asylum spaces really are connected to territorial entry. I think that's a tremendous restriction of the current system, but I'm going to hold on to these thoughts. If you want to ask me during the Q&A, I'll be happy to address this. But if we think about asylum spaces in a world of greater mobility, in a world of deep inequality and ongoing violence and instability, it just seems extremely restricting to ask individuals to actually enter another territory in order to get a right of protection. And again, remember, these are states that at least formally, although the convention asks them not to keep the borders open, we know in the real world have put many, many restrictions to mobility. So the second point is about actors. Let me turn to the third point, which is about agency. And I think this is a problem that we all face when we think about, massive movements or 60 million people and who is going to address their plight. Especially as lawyers, this is almost a professional deficiency, right? We run to rules, or we want to have institutions, or we want to have some kind of a guiding institutional structure. But I think what we might miss out, and this again, it's not a critique to these papers. I think again, it's thinking about the field. I think we should pay much more attention to the agency of the individuals who move. Their agency in the sense of where they want to move, why they are moving, what their wishes and aspirations are. Just like anyone in this room, they might want to make significant choices about their own lives and how they can shape them under very, very dire consequences. So I think that aspect of agency and how to put that into our new architecture is something that has to be, I think we need to pay more attention to that. And I don't think that there's a one-size-fit-all kind of solution, but I do think it has to be a question on the agenda. It has to be one of the main considerations that we take with us as we move forward. And just to give you a concrete example, even Germany, which started this year, with tremendous generosity, really, I just literally moved to Germany at the time in September, and I was struck by the overwhelming generosity of every individual. Just people would bring in clothes or just small acts of generosity which people took. And now we're meeting here in June, and of course the political mood is so different, and it's less than a year, it's just 9 months. So just to, these issues are very, very volatile. But if we want to take into account agency, I'm bringing Germany because the new integration law that was just passed here in this country actually says that in order for refugees to maintain the kind of benefits that they have, their mobility, internal mobility within Germany is restricted. So even in this country, so we haven't gone into the developing world even in Germany, a sense of restricting the agency and mobility of individuals who have fled quite traumatic circumstances. So this is why I want to push this point and suggest that this is one of the things that we have to think about as we think about forced migration and the rights of refugees. And just in the interest of time, let me close by changing gears a little bit. That is, I want to close with a quote from Hannah Arendt. And again, I think it's different to quote Arendt when we are here at Humboldt University in Berlin, literally a stone throw away from the Faculty of Law, where in 1933 the burning of the books occurred literally just a few meters or 100 meters away from us. And if you want to see actually a beautiful memorial, go and see the Empty Library by Micha Ullmann. It's one of the most beautiful memorials, I think, in Berlin, which has a lot of memorials. But just to quote Arendt, and I think I actually want to quote Arendt in a way by posing back, returning to the initial challenge that Philippe asked us, which is, can we draw a direct analogy to the 1930s? I think we cannot. I mean, I think that the basic institutional structure is so dramatically different that it would be hard to draw a direct analogy. The concern in the 1930s was that there was no regime, no rules, no basic human rights protections. Now we actually have those. They're not implemented, and we heard from Alex, even if they're implemented, they are yesterday's challenges rather than tomorrow's challenges. But still, I want you to hear Arendt, because she wrote, as we all know, in the aftermath of World War II, right after the Holocaust, and she brilliantly observed the following. This is her concern with refugees. Suddenly, there was no place on earth where migrants could go without the severest restrictions. No country where they would be assimilated. No territory where they could found a new community of their own. So while the world has dramatically changed, and to some extent, we can debate whether for the better or the worse. I would actually say most likely the better. But the world has changed clearly, dramatically, since the publication of The Origins of Totalitarianism. But still, the basic concern that motivated Arendt to write these words, that is the basic plight of refugees, of displaced persons, still remains with us. That is, it's still today, 2016, is one of the biggest, one of the most pressing, and unfortunately for all of us, this requires a lot of work because it is also one of the most difficult human rights challenges or issues that we face today, the greatest challenge, one of the greatest challenges of our times. So let me close here. I've overgone my 15 minutes, so thank you very much, and I look forward to the conversation with the panelists.
Thank you very much, Haylet. What I propose for the 15 remaining minutes is that we take a few questions, if there are from the floor, before I give the floor to the speakers to comment on the comments, maybe, and react to each other. So are there any questions? Yes. Take the mic, please.
Thank you. David Abraham, and my question is mostly to Alex. The world you describe for the future, one in which there is further immiseration of the peasantries, especially of the global south, desertification of Central Africa, failed states all over, in some ways describes the world of the late 19th and early 20th century better than it does the world of 1950 to 1990. Those masses in percentage terms that moved around the world, say from 1860 to 1919 or 1914, are quite similar to today. And the answer was worldwide migration, which sovereigns around the world welcomed. Now, Chancellor Merkel can't get 500 million EU residents to accept 1 million immigrants amongst them. Do you see any prospect, rather than a public-private partnership, for countries, sovereign states, to reinvest in bringing immigrants willingly?
Are there any other questions? Maybe we just get several questions and then there is one behind.
Thanks very much, Ruvi Ziegler. So it's a question I think links Alex Aleinikoff's paper and Ayel's response, and it's on the level between the state and the global community or the international responsibility sharing. And it's a question whether regional solutions, which include, in some areas of the world, freedom of movement internally, and we certainly see this in Schengen, but we see this in Latin America to a large extent, and some might argue in Africa, coupled with a degree of matching of individual preferences within that region and the needs of states. Do you see that as a challenge to a universal perspective on refugee status or rights? Or do you think this actually might be a promising lead to promote? Thank you.
Two other questions here, Justin. If I can ask you to have brief questions, because we have another one on there.
Yes, I'll try to be as brief as possible. My question is related to the looking at international law in a new philosophy proposed by Ronald Dawkins in his 2013 paper, and how it will be influential in understanding the refugee situation. So in the 2013 paper, Dawkins proposed a non-positivist way of looking at international law. He says that it is not consent which is the basis of international law, but it is moral legitimacy. So states essentially obey international law because they want to be legitimate, and it is morally required for them to obey international law in that sense. And international law is essentially for the benefit of individuals and should serve the interests of individuals as well. I just wanted to have your views on how that view of international law will help us build a new mechanism in the area of refugee rights.
There's someone in the back of the room.
I indeed appreciate the observation that there should be shift from humanitarianism to development. But my question to all panelists, should we also not critique the present refugee law from the standpoint of ableism? What about the intersection of refugees and disability-based discrimination? After UNCRPD, adoption of UNCRPD in 2008, can I not argue that people with disability face persecution throughout the world? And if they want to migrate from one country to the other, why not the definition of persecution be changed in the light of ableism? So the new architecture which is talked about, does it also refer to the concerns of people with disability? And disability is also now coming because of the civil wars. So it's not only that those who are disabled by birth, but many people are acquiring disabilities after civil wars as well. So what this new architecture has to offer?
Can you make it brief, please, or else we cannot take any other question and get the answers. Thank you. Last one.
Making a link with the presentation of this morning, how do you think that the refugees and their access to nationality and the reintegration to their community can help them, can help the community to support and to solve some of the problems that are linked between racism or discrimination against refugees? So how do the access to nationality should help refugees, not only in the countries of destination, but also when they go back to their countries of origin?
Okay, thank you, Ayelet. I will give you the floor first because you were the addressee of the first questions, and then we'll pass the floor to Alexander, then Philippe to close the panel.
I think we're so short with time. Let them go first.
Well, these are interesting questions, and I'm just going to do like one sentence for each because we're out of time here. But on the prospects, David, I don't know. Unless we don't. I mean, I hope we can do something. I hope we try. I think the crucial thing is actually showing the system is well managed and well controlled. That was the huge problem in Europe, that Europe didn't get ahead of this problem 3 or 4 years ago. And if they had, I think you could have brought several 100,000 refugees in every year. The United States could have done the same, would have relieved the pressure, but it was not. So I think that takes care of a lot of the political opposition. I think you can do it in hosting states as well, that if you bring development money in, you can bring people along slowly. But I think the second question helps answer the first. I think the regional idea is a very smart suggestion. There are examples of this where if you leave it to regional arrangements, actually countries, there's free movement like under ECOWAS or Mercosur or other arrangements, actually can be very helpful in working some of these problems out. On the Dworkin problem, it's a really interesting question. I'm thinking about this not as theoretically, but just in my experience over the last 5 years at UNHCR and seeing states around the world behave. It's a really interesting mix of self-interest and moral suasion. States wanted to be seen as respecting refugee rights, even when they weren't. No state ever stood up and said, we don't believe these people ever. It was always, and there was often, I often said to the United States State Department, the largest funder of I said, are you pursuing the interests of the United States? I tease them about them because the bureaucrats in charge of refugee relief in the U.S. were really humanitarianly driven. It was really quite startling to me. And I saw that in many other countries around the world, that the humanitarian appeal here, because of the history of the last whatever number of years, is pretty strong in states, at least on migration, much tougher. But on refugees, I think it really was there. Now, national interest always comes in, but it was an interesting mix. The question was about disability, was a question here. As I say, I think the definition, I think there are expansions that can occur and may need to occur of the definition. I haven't thought about that in particular. One way this can be handled within the existing law is that membership in a particular social group is a ground for being recognized as a refugee, and it may well be that disabled people in the sending country are in fact a social group. That wouldn't be a very hard claim to make in many situations. May be able to be handled within the current situation. And the last question, access to nationalities. I said Article 34 of the Convention does say there should be some access to nationality. States should think about access to nationality. I think it's really important. One of the most important solutions that happened in the last 5 years was Tanzania granting citizenship to 165,000 Burundians who had arrived there in 1972. They'd been there forever. But that was a huge step in terms of regularizing rights. When they go back, they should have the nationality of the country that they were sent from. Last point on this. When the convention was first drafted, and when Arendt wrote about refugees, she was really writing about stateless people. And the convention was originally called to write a convention about statelessness and refugees. The refugee part was sort of secondary. It was people who had no rights because they were not members of a state. The statelessness got taken away. The Refugee Convention was written because it was mainly about people already living in a place. It was surplus refugees, if you will. And statelessness came back a few years after that. But that the issue on so refugees generally are not stateless, and they have a citizenship if they return home. There should be serious efforts about making them fully integrated and naturalized in the countries that give them status.
Thank you. Well, we've very little time available, so I will just deal with one or two of the questions. I'd like to thank Ayelet. It's given plenty of pause for thought on the points of commonality and the points of distinction. Of course, you've come out very strongly at the end, rejecting the sense that what has come before may in some way help us understand what is happening now.
That's not what I said. I said it's just not an analogous situation. I think it's actually extremely productive to look and to learn what not to do. So just to qualify that. So it's not that it doesn't matter. I think it's very significant, but I just don't think it's, you started with saying that EU-Turkey now is analogous to 1935, and I thought that was too strong.
Right. I mean, I raised it as a question. I certainly don't make the assertion that it is analogous. I think there are analogies there. But I think that question needs to stay out, and I certainly need to reflect on that question. I want to come back to Alex's paper and also the responses that you've given just now. I mean, I'm often accused of being, a hopeless optimist. But I think you make me look like a miserable pessimist. Because you, in relation to the European context, I'm going to be very careful now because I want to make sure that I understood you correctly. Your point was essentially the problems in Europe could be relatively easily solved. I wish could have been. I wonder if that's right. I mean, living through decisions in the United Kingdom, in which just recently Parliament voted to not allow 500 children, unaccompanied minors in Calais, to be allowed into the United Kingdom. Quite what that says about the state of public thinking right now in that country and in other countries. The complete closing of the door, because most of the refugees who may come are of an ethnicity or of a religion which is seen as alien, I'm afraid does raise direct comparisons with another time. And so I wonder whether we have got ourselves into a place in which the kind of tinkering, a new protocol, a new institutional structure, a new arrangement is just gone. That actually the fundamental challenge that we face goes much, much deeper. It seems to be a return to identity politics. It comes in a sense to the question of nationality, because I can tell you in most countries the idea of granting nationality is going to be kicked out. In fact, what is happening right now in many countries is there is a return to stripping people of their nationality, and we seem to be going back into a very different direction. The core of the whole issue, and I'm coming now to the question on changing the way we think about the international legal order, away from a positive approach to some other approach. Oh, how wonderful that would be, but we are where we are, and we have what we have, and the system, regrettably, is not going to allow those kinds of changes. The truth, I think, is that we live in a time of increasing disconnect between the legal structures that have been created, particularly in the post-war period, and broad public acceptance of those structures. And I think it was Helene who said we do need to focus on what the causes of that are. You can illustrate it very simply by reference to a small town in northeast England, which is going to vote en masse against remaining in the European Union simply because of the arrival of a significant number of families from Poland or Hungary or wherever it might be, which has changed the identity of the town. I don't live in a part of London where I feel that change, but I do feel an increasing responsibility to take account of that real perception of people, that something is going on in which the disconnect between the legal order that we have created and the world that we live in is becoming wider rather than narrower. And that, I think, touches into other issues, whether it is TTIP, whether it is legal arrangements on climate change, but it also requires us, I think, to go back to what Alex says, which is to look at things holistically. I've been remarkably struck by the fact, as a closing comment, and I will stop here, that my country dropped a lot of bombs on Afghanistan and on Iraq and doesn't wish to take a single refugee from any of those territories or countries. Germany, as far as I'm aware, dropped not a single bomb on Afghanistan or Iraq and has taken over 1 million. And that is fueling a sense, I think, again, of disconnect as between states. And if we're going to grapple with the current modern issue of refugees, whether in Europe or whether beyond, and as you rightly say, beyond is even more challenging than in the European context, I think we do need to begin to start looking at the causes of what is happening, which does require us to look at the nature of the international order and the increasing disparities between those who have and those who have not. And to simply tinker with the arrangements on refugees, I think I think we need to go beyond that. It's not said, Alex, in a pejorative sense. I just think we've got a much bigger problem than the one looking at it, the micro of our world of law that we look at causes us to look at.
The chair has been generous and she has given me 1 minute. So I just, Philippe, I think I actually want to pick up on your last point because I think it's a very significant one. And I think that was the point where I said you two actually connect, where you say it's not just law, there's also politics, it's not just institutional structures, there are people in the sense of the people who need protection, but we have states which under the current system do have potentially the right to exclude, and I think that explains partly your dilemma with the UK, and I think, Philippe, there I actually side with you more than with Alex, in the sense that I think for the EU, it was not just it's not just that the response was too late. I think that there were a lot of reasons for many, many countries not to take action. And they did have to do with the fact, partly with failure of solidarity or cooperation, but also partly the fact that political leaders are accountable to their own political communities. So that's partly the dilemma that we had. That's what I meant, that we faced. That's what I mentioned earlier. And that's something that we have to think through. And maybe raising awareness and explaining that it's part of our shared common humanity, that each and every one of us could, in theory, stand in the shoes of the refugee. Perhaps that would change the approach. So I think it is connected to questions of where people perceive themselves in the world. It is connected to questions of deep inequalities. So I think that's really where our challenges lie. And they're difficult challenges. They go way beyond law per se. And I think not confronting them is part of the mistake that we're seeing today. Because if we don't confront them head on, we might just get these very, very reactive, strong, and in many cases, at least again, the UK as an example, very negative, very restrictive kinds of movements. And I think that really for us, for everyone in the room, is a great challenge. So that's partly where, I also tend to be very optimistic. I think on that front, I think we have to at least have a dose of pessimism there, at least, or we have to think through how to address these very, very deep and complicated issues.
Thank you to all. First, this panel was a true conversation, and this is great. Thanks to the panelists for being so involved. And third, what they said is of concern for us, not only as lawyers, but as citizens. Thank you for the audience too. I give the floor to Gronia de Boca.
before we break up for coffee, can I just remind everyone that we're about to start our first of 3 concurrent panel sessions, and I've been asked to remind all of you of the prisoner's dilemma. In case you're wondering what I'm talking about, the prisoner's dilemma in this instance means that if you're inclined to go to your own panel in which you're participating, and otherwise perhaps to see a little of Berlin, just remember that if everyone does the same, there will be no one attending any of the panels. So I would like to ask you, please, on behalf of all of those who've come here, to attend more than your own panel, to look at the rich array, the program that has been put together and all the people who've come, and make sure you do attend some of the panels. In the meantime, enjoy your coffee.
Of the League of Nations High Commissioner for Refugees, James MacDonald, as I mentioned, in the autumn of 1935. Janowski wanted to include in the letter, as an annex, a far-reaching call declaring the rights of all individuals and minorities, going significantly beyond what international law at the time provided for. James MacDonald had decided to resign in October 1935 as commissioner in the face of what he called a total political failure at the League of Nations to support his efforts to safeguard non-Aryan refugees, both Jewish and other, resulting from the implementation of policies of discrimination and expulsion adopted by the recently elected National Socialist government in Germany. MacDonald recruited a number of individuals to assist him in drafting his letter of resignation, almost exclusively from the United States and Britain. A particularly contentious issue arose with regard to the question of what rights, if any, did the refugees have under international law, and what obligations, if any, did states have under international law, including the right of what MacDonald called humanitarian intercession, to intervene, to protect the well-being of humans who were under threat. I often remind my students that 70 years in international law is both a short and a very long time. There were no rules of international law as at that period which prohibited a state from imprisoning, torturing, enslaving, killing, disappearing its own nationals as a matter of international law. That, of course, only changed after 1945. So we have to immediately put ourselves in a different mindset. And you have to imagine yourselves in this room back in 1935 as to the paucity of international rules that existed. The content of the annex, what to put in it and what to exclude, turned on sharply competing considerations as to the balancing between the articulation of legal principles, if not rights, on the one hand, and deference to matters of political risk on the other. As Janowski put it in his unpublished memoir, and I quote, "There was a good deal of discussion as to whether MacDonald should or should not make such a statement, whether the lot of the persecuted non-Aryans might be worsened by such a statement, whether the Nazi government should be provoked, whether the well-disposed Western powers should be troubled with a small matter like human or minority rights." End of quote. You can take those words and you can superimpose them almost word for word, not in relation to the particular government or the particular individuals, I think, with the current situation that we face today. Just to pause momentarily, we all know that last week the German parliament voted to characterize the events, the killings by the Ottoman Empire of the Armenians as a genocide, which caused the immediate recall of Turkey's ambassador to this country. So offensive was it deemed to be. And the executive in this country is obviously principally concerned not with the issue of principle, but with the impact of such a characterization by the German parliament on the future prospects of the EU-Turkey agreement. That is at the heart of the real concern. So there is a real politique here, which was as live in 1935 as it is today. MacDonald was an American academic, an analogy with our speaker who will follow me, Alex, who taught history not at the University of Indiana and who served as chairman of the Foreign Policy Association in the United States. In accepting his position as High Commissioner for Refugees, his job was to negotiate and direct the international collaboration necessary to solve the economic, financial, and social problems of the refugees. He resigned within 2 years of being appointed, and he resigned, as I said, because of the total lack of support from governments across the board. He wanted to draft a resignation letter that would shock governments and public opinion into action. And he recruited not only Oskar Janowski, but a young American academic called Melvin Fagan, who were both delegates of the American Jewish Committee. And he involved also their British counterparts at a more senior level, influential intellectuals who included amongst the group Professor Norman Bentwich and Professor Hirsch Lauterpacht, who at that time was at the London School of Economics. Internal differences meant that the project started as an American-led effort. Janowski and Fagan determined the scope of the project as being to produce an annex that was a scholarly and forceful memorandum which called attention to the plight of the refugees, the burden of Nazi policies, and the legitimacy of international concerns. And in particular, they wanted to identify precedents to stop this kind of behavior from proceeding. Should the letter contain an annex, and in particular, should the letter contain a statement about the rights of religious and racial minorities, which might be a part of a so-called Bill of Rights in relation to these displaced persons, but also an indictment of the persecuting country. In preparing the annex, the first drafts were written in the United States. Janowski devotes a full chapter of his memoir, chapter 17, which he describes as a day-to-day record of the MacDonald letter of resignation, and it is well worth reading. It recounts a period of just a few weeks in late 1935, reconstructed from memory, good and reliable memory, from MacDonald's diaries, from Janowski's diaries, and from the correspondence which is preserved. In America, as the project started, American academics supported a far-reaching call for
a drawing, I would say, a landscape of the current state of affairs. And then from then, Ayelet Shahar will have the difficult task to comment on these very different papers, but if we reflect a bit further, and I've had the privilege to read the papers, we can see, in fact, that they are focusing on the same issue. Has the situation improved along the century and in the beginning of this 21st century or not? I'm not sure that our speakers have exactly the same answer to this question, but now I will give them the floor so that you can also have your own opinion on this. So, Philippe, you have the floor.
Thank you very much, Hélène, and thank you to the organizers. I'm bowled over and struck by the extraordinary richness of this event, participants, subject matters. It really is a testimony to a very vibrant area. As Hélène has said, I'm going to go back 80 years, and I'm going to talk about an issue of movement and migration that, of course, is not disconnected from other events that took place in this city, and really posing a question which I can't even begin to answer. Namely, we were then at a time in which there were no international rules dealing with the kinds of issues that this panel is going to address. Today we have a system of rules and we are bound to ask ourselves the question, what has actually changed? I have spent much of the last 7 years immersed in the period 1914 to 1946, exploring the lives of 3 men. 2 of them were prosecutors at the Nuremberg trial, and 1 was a defendant. The prosecutors, or on the prosecution teams, were Hersch Lauterpacht, who was promoting the concept of crimes against humanity and the protection of individuals, and Raphael Lemkin, who worked not, as Lauterpacht did, with the British team, but with the American team, promoting the concept of genocide, the protection of groups as opposed to individuals. They shared a number of things, although they had strong differences in respect to the question, how does the law best protect the rights of individuals, minorities, and groups? And of course, both of them were themselves refugees, having moved from their place of origin in Galicia, in what was part of the Austro-Hungarian Empire, and eventually became Poland, and is now the Ukraine. And the answers they gave to those questions have thrown up a number of further questions which I've been exploring. They found themselves on the other side of the courtroom, the famous courtroom 600 in Nuremberg, with a man who may once have been in this very room. His name was Hans Frank. He was Adolf Hitler's personal lawyer from 1928 to 1932, and eventually became Governor General of occupied Poland. And he had a very different conception of the rule of law, the rights of individuals, and the rights of groups. So immersed in that period and invited to address the subject of migration and movement on this plenary panel, I feel firstly somewhat of an imposter because I am not an expert in the law of refugees or migration. I come to it as a general international lawyer with a keen interest in matters historical. And I settled on one tiny story that emerged in all of the research that I did that struck me as interesting, possibly, in illustrating an experience that took place in the autumn of 1935 and concerned, as Hélène has said, the letter of resignation of the Commissioner for Refugees under the League of Nations, as the entity then was. And in particular, the question which dominated a vibrant debate between a small number of individuals in drafting that letter as to the relationship, if you like, between politics and law. The reason I've taken that topic and the reason I felt it was not inappropriate to take that topic is that even with my limited background in issues of refugee status and migration and paying obvious attention to the recent EU-Turkey agreement and the manner in which it seems to have bulldozed through many of the EU's own rules on migration and refugee status, as well as aspects of the 1951 Convention, was that that agreement also raises fundamental questions about the relationship between politics and law, between pragmatism and principle. And so I want to use this episode and this story that I'm going to share with you, which probably many of you will not have come across, although I express my deep appreciation to Professor James Loeffler, who was the person who first introduced this story to me. And perhaps in the discussion we can then ask the question, to what extent, even from this tiny experience, can we draw lessons that may be worth thinking about. The paper or the speaking note that I've prepared begins by raising questions about context and in particular the situation that pertains right now in Europe concerning a very large number of migrants and refugees, economic, political and other, coming from various parts of the world, including of course Syria and Iraq and Afghanistan. The arrangements that have been put in place in the spring of this year raise, I think, the most serious questions as to the compatibility of those arrangements with existing international obligations and highlights the acute but delicate relationship between political realities and constraints on the one hand and our sense of a commitment to the rule of law, including the rule of public law and international law, on the other. It's often said in the media that the issues we face are today without precedent. I don't think that is right. I don't think it's without precedent in terms of scale, and it's certainly not without precedent in terms of principle. The episode within the episode to which I want to refer concerns the efforts of a young American academic, Professor Oscar Janowski, a historian, to prepare an annex to the letter of resignation.
All right. Please sit down. Please sit down. There will be a coffee break after the next session, and you can continue your conversations. So I want to begin with an organizational announcement. As you know, if you look at the program, we have two kinds of panels. We have the plenary panels, the plenary sessions, and then we have the ordinary panel sessions. Now, all of the plenary sessions, all of them, today, so this one, but also tomorrow and on Sunday, will be taking place here. It's in the program, but just for your orientation, they will all be taking place here in the Auditorium Maximum of the main building of Humboldt University. After this session, and for the panel sessions, the ordinary panel sessions, so not the plenary ones, but the ordinary ones, they are distributed among 3 buildings. Now, all the information you need, you'll find in the program, in the map on page 6. But just for your orientation, there are 3 buildings, they're all within easy reach, and you can all get there from here within 3 minutes. So if after this panel you want to orientate yourself, either ask someone in a red shirt or take a good look at the program and the map and you'll be oriented. Okay, thank you. We go to the panel.
Thank you very much. First of all, I would like to say how pleased I am to attend this conference, and I thank the organizer for having invited me to chair this plenary. Not that I am a great specialist of migration and movement, but I will specialize in giving the floor to others who are far more gifted than me to speak about this topic. So our panel will try to show how much the problems we are currently facing are not new. And I don't mean nothing has improved, of course, but nevertheless, the problems are not less acute. Both our speakers will invite to contextualize the issue and to take a historical perspective, although they will do it in a very different way, one to the other. So the first panel, in fact, will be Philippe Sands, who is professor at UCL and author of a recently issued book, East-West Street, you can see it, and on the origins of genocide and crime against humanity. He will speak about 1935, the year when James MacDonald resigned from his office of High Commissioner for Refugees of the League of Nations, at a time when there were no rules of international law. And then Alexander Aleinikoff, who is former UN Deputy Commissioner for Refugees and currently at Columbia University, will speak about revitalizing the international response to forced migration and